wise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Nashville on May 4th through the 5th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page.
Welcome to FCPA Flash. This is Professor Mike Koehler, and in today's episode I'm pleased to be joined by Marc Bohn. Marc is a lawyer at Miller & Chevalier with an active FCPA practice, and today's topic is going to be disgorgement. Disgorgement, of course, is a general legal principle at issue in most SEC enforcement actions, but it's also an FCPA relevant issue given that in recent years approximately 90% of SEC recovery in FCPA enforcement actions has been the disgorgement remedy. So thanks for joining us today, Marc.
Happy to be here. Thanks for inviting me.
Now, this is really a timely topic. Disgorgement has had its moment in the sunshine, so to speak, because of a couple of appellate court cases in 2016. And even more recently, the Supreme Court recently accepted cert in a case called Kokesh versus SEC. And to begin our discussion, could you provide to the listeners a brief background on the Kokesh case and the general issue before the court?
Sure. So Kokesh involves a New Mexico investment advisor, Charles R. Kokesh, who is accused of using a couple of investment advisor firms that he owned to misappropriate nearly $35 million in publicly offered funds from several investment companies in the tech sector from about 1996 to 2006. Kokesh was convicted by a jury and the court issued an injunction ordering him to disgorge $34.9 million plus 18 or so million in prejudgment interest and a civil penalty of $22.4 million relating to conduct that occurred after 2004. He appealed the decision, arguing, among other things, that the injunction and disgorgement needed to be set aside because the claims accrued more than 5 years before the SEC brought its action, and therefore were time-barred by the statute of limitations in 28 U.S.C. 2462. I'll just refer to that as 2462 from here on out, which governs the imposition of civil fines, penalties, and forfeitures by the federal government. In support of his appeal, he cited, among other things, a recent 11th Circuit decision, SEC v. Graham, which had held that the statute of limitations applied to disgorgement.
And you mentioned 2462. 2462 is the catch-all statute of limitations that is applicable to FCPA offenses as well, because the FCPA does not contain an explicit statute of limitations. And as you mentioned, this topic is, sort of an in-the-weeds type topic in the sense of, is disgorgement a fine, penalty, a forfeiture, or is it something else? And you mentioned the Supreme Court decision that's also sort of lurking here in the background, and that's Gabelli versus SEC. And can you just step us through what happened in that case and how it might be relevant to the Kokesh decision?
Sure. Quickly, in Kokesh, the 10th Circuit rejected Kokesh's appeal. They held, among other things, that the disgorgement order was not subject to 2462 because there was nothing punitive about requiring Kokesh to disgorge the misappropriated funds, and in the court's view, disgorgement was not akin to forfeiture. In support of its decision, the court cited a string of precedent finding disgorgement not to be punitive or not to be a penalty under 2462 because it was remedial in nature. And the court explicitly rejected the Grand Court's approach and relied on Black's Law Dictionary to distinguish the definition of forfeiture as a punitive taking of property that facilitated the crime. So Gabelli is a 2013 Supreme Court decision that rejected the SEC's view of when the statute of limitations clock begins to tick, either when the violation is complete or when it is discovered. And the facts of the underlying case, which involved alleged violations of the Investment Advisor Act, are less important here, except to note that Gabelli and his co-defendant appealed the Second Circuit opinion permitting the case against them to proceed. And even though the SEC had filed its complaint seeking civil penalties more than 5 years after the conduct occurred, but less than 5 years after the SEC learned of the alleged violations.
And Gabelli was a unanimous Supreme Court decision, correct?
Yeah, so the Supreme Court held unanimously that the statute of limitations governing the SEC's pursuit of civil penalties or forfeiture under 2462 begin to run when the offending act is committed or finished, not when the Commission becomes aware of the misconduct. However, Gabelli left open the question of whether claims for so-called equitable relief fall under the statute of limitations. But nevertheless, the Supreme Court's unanimous rejection of the SEC's aggressive interpretation, it may have presaged Graham, prompting the 11th Circuit to reconsider how the statute of limitations should apply across the board in FCC cases.
So what do you think the Supreme Court's decision in Gabelli, this unanimous decision, suggests about its acceptance of cert in the Kokesh case? I mean, the court is, basically the same. Obviously, Justice Scalia is absent, but and there's a variable, of course, with the soon-to-be announced Supreme Court nominee of President Trump. But what do you think the Gabelli decision suggests about why the court accepted cert here and perhaps how it might rule?
Not a great deal. Predicting how the Supreme Court will come out in Kokesh based on its decision in Gabelli is a fraud exercise. But it's worth noting, as I suggested earlier, that the Gabelli did not address the question of whether claims for so-called equitable relief fall under the statute of limitations, and its unanimous rejection of the SEC's position does suggest that the court is open to reconsidering the scope of the statute of limitations in cases like this. As far as reading the tea leaves go, I'd be treading on thin ice, but I would note that several Supreme Court watchers I know think Kokesh has to feel good about his chances. The Solicitor General did not oppose cert, which some court watchers see as a positive development for the petitioner, with the Solicitor General possibly gambling that the case would be heard by 8 justices, so maybe the government has a better chance if it's not before a full court. But
so let's say, go ahead.
But it's difficult to say. So it's unclear whether the court's going to hear the case this term or next. Normally, when a cert is accepted this early, it would be heard this term, but because President Trump is preparing to nominate a new justice to replace Scalia, the court could slow walk the scheduling of oral arguments in certain cases, which could mean that certain cert grants get pushed to next term.
So what would be the significance of a Supreme Court decision overturning Kokesh? In other words, finding disgorgement is subject to a 5-year limitations period. Again, the Kokesh case is not an FCPA case per se, but the issue presented is definitely relevant to FCPA enforcement actions brought by the SEC, given the dominance of the disgorgement remedy. So practically speaking, what effect do you think, if any, this might have on corporate compliance with the FCPA, SEC investigations, and enforcement of suspected FCPA violations?
Well, such a decision would certainly put pressure on the SEC to take measures to resolve enforcement actions more quickly. As you know, I mean, in certain instances, investigations can drag out for a decade or more. Such an effort by the Commission to increase enforcement, the speed of its enforcement action, could mirror recent attempts by the U.S. Department of Justice to accelerate its own pace of FCPA enforcement. The DOJ has done this by working with the FBI to create kind of squads devoted to the prosecution of the FCPA and money laundering violations. They've increased the number of DOJ attorneys devoted to FCPA cases by 50% or more, and they've implemented or introduced the FCPA pilot program to encourage voluntary disclosures, and all of these things I think can have an effect and speed the pace of investigations and prosecution. Such a decision could also discourage defendants from signing tolling agreements to extend or entirely waive the statute of limitations. Given the importance the SEC places on cooperation, however, as a factor in settlement negotiations, it's likely that companies and some individuals will continue to sign such agreements. But this decision should at least increase the leverage that these entities and individuals have, who may be now more aggressive in pushing the SEC to narrowly define the scope of their tolling agreements or waivers.
Yeah, because it's interesting when you look into most, I'm not saying all, but when you look into most FCPA enforcement actions and read the allegations or the findings, one quickly comes to the realization that the conduct is not just old, in other words, longer than 5 years, but in some cases, very, very old, 7 to 10 years, in some, outlier cases, I guess you could say it's, 15 years or longer. And I know this is not an FCPA enforcement action per se, but the recent Rolls-Royce enforcement action brought by the UK Serious Fraud Office literally goes back, 28 years. But as you mentioned, legal elements, legal principles, statute of limitations is certainly a bedrock legal principle. These things tend to only matter in the context of actual litigated adversarial proceedings. And you mentioned that the name of the game oftentimes in corporate FCPA enforcement actions is companies demonstrating their cooperation, and as part of that cooperation very early on signing tolling agreements or cooperation agreements where they waive statute of limitation defenses altogether. So you put this all together, and let's say the Supreme Court does overturn Kokesh and does find that disgorgement is subject to a 5-year limitations period. Is that even going to matter in the vast majority of corporate enforcement actions, given the dynamics that we both just touched upon?
Right. I tend to think it would matter. There definitely is a difference in the type of negotiations you have with the SEC and DOJ. The SEC is more emboldened to go back and pursue older conduct because heretofore they've interpreted the statute as not limiting them in that regard, while the DOJ is generally more amenable to arguments relating to statute of limitations and other elements like that. So I tend to think that it would definitely increase companies' leverage. I also would note that in a lot of the cases that you mentioned where the government is citing conduct that goes back in many years, I think those cases often hinge on the company being characterized as out of touch with compliance, and they use that as a way to contextualize that the deep-seated problems within the company, and typically there are violations within the statute of limitations period that the government can pursue, and so including facts about those older violations adds flavor, but I don't think excluding that would preclude a prosecution in those cases. So I do think that it would help companies, but like you note, I mean, most of these corporate settlements aren't adversarial proceedings, and so while it does give defendants more leverage in negotiations with the government. If they're still willing to enter into tolling agreements and sign waivers, its effect will be minimum.
You raise a good point there that these resolution documents, tell a story, and some of the allegations, as you mentioned, are contextual. And even if some of those contextual allegations concern conduct from a very long time ago, there is sometimes, although not always, sometimes a situation in which there is conduct that occurred within a 5-year or, conceivable statute of limitations period. But, then you get to the end of the enforcement action, and the disgorgement amount is just sort of, set forth there, and it's impossible to really tell if the SEC was seeking the disgorgement amount only as to the very small sliver of enforcement, or allegations within the limitations period versus all of the allegations. And it would really be nice, and I'd value your input on this, if the SEC could perhaps, give us a little bit more detail as to how they're figuring out this disgorgement amount. There's, in the DOJ context, not that the DOJ sentencing guideline calculations are crystal clear in all cases or necessarily transparent, but at least we do see a calculation, whereas in SEC enforcement actions, you get to the bottom of the enforcement action and it just says disgorge X, and there's really no calculation or insight or even transparency as to how that number is calculated. What are your thoughts on that?
Yeah, I mean, it'll be interesting to see how it affects, if, assuming Kokesh is overturned and the Supreme Court applies the statute of limitations to disgorgement in the SEC context, it'll be interesting to see how that affects disgorgement conversations. I mean, it is a little bit of a black box, particularly in the FCPA context where you don't have case law litigated FCPA cases to add more flavor, but the SEC has long been applying disgorgement in general securities litigation context for years, and so you do have some baseline in the SEC that they're required to distinguish between legally and illegally obtained profits, and so they need to identify a causal link between the unlawful activity and the profit to be disgorged, and assert its right to disgorge kind of any illicit profits that stem from the wrongdoing. And so if companies are still willing to waive and toll, I think the SEC would certainly have the power to disgorge within the period of waiver or tolling, and hopefully it's not abused. My experience, if a law like this is set, the prosecutors, I felt, have generally been reasonable in the cases that I've worked on, and when we've gone forth and made good faith arguments, we've had good discussions, and often there clearly are times where there are disagreements, but often we're able to make headway and come to a place where both the company and the government feel good about the outcome.
Yeah, and just a big picture point for the listener's benefit is, a lot of times you look at FCPA settlement amounts, and they certainly have appeared to increase over time, and part of that, of course, is the SEC's use of disgorgement in FCPA enforcement actions is a relatively, new invention, so to speak. Disgorgement is not mentioned in the statute, and I believe that the SEC first used the disgorgement remedy in an FCPA enforcement action in 2004, which was relatively recent when you consider the age of the FCPA, and it's really sort of at that time where I think you see settlement amounts, getting bigger and seemingly even bigger with each passing year. The final question I have is, just from a counseling standpoint and your interactions with some of your corporate clients, do you ever get rolling of the eyes or you got to be kidding me type comments from clients when they look at these enforcement actions that concern conduct from a very long time ago, And if so, how do you deal with that? You mentioned that sometimes these resolution documents tell a story and provide contextual facts and not necessarily facts that determine the outcome. But how do you deal with perhaps some cynicism from clients concerning the very old conduct that's alleged in many of these actions?
Yeah, I think when actions come out to pursue conduct that occurred decades ago, that's definitely of concern to clients. In my experience, where a company has turned the ship around and can evidence that it has a compliance program that is evolving and that it addresses the key components that the DOJ and SEC expect a compliance program to have, that the government's understanding about these things. And I've been in presentations where the government is asked about historic conduct in a particular country or challenges that a company has faced, and we've recounted allegations that are old and noted how the company addressed them and what they did to resolve them, and how the compliance program currently was functioning, and the SEC and DOJ didn't show much of an appetite to pursue those things. So I do think that a lot of this is contextual, and that if companies have implemented a good compliance program, that the DOJ and SEC generally aren't going to be or have the appetite to pursue conduct that's decades old, unless they can kind of make an argument that there's fruits of the poisonous tree that are still benefiting the company, maybe, but I mean, I think that would be a case-by-case basis and pretty factual specific.
Well, thanks for providing your insight today. The guest has been Marc Bohn. He's an FCPA practitioner at Miller & Chevalier, and our focus today has been, on one level, a narrow issue, the Supreme Court's acceptance of cert in the Kokesh case, a case that will present the Supreme Court with the issue of whether disgorgement is subject to a 5-year limitations period. But as Marc has mentioned, and as we've discussed, this does have relevance to the FCPA enforcement context, given the prominence of the disgorgement remedy. So thank you, Marc, for taking time out of your day to share your insights with the listeners.
Hey, I was happy to do it, and look forward to speaking with you again at some point.